Hi everyone, thank you for tuning in today to our Facebook Live discussion. My name is Maura Clancy. I'm here at Chisholm and Kilpatrick in Providence, Rhode Island. I'm here with Mike Lestrito and Christian McTarnigan. Today we're talking about VA back pay. So we've got some topics prepared that we're ready to discuss pertaining to issues surrounding how VA decides what kind of back pay you're entitled to. But just as a preliminary matter, we are going to be posting additional materials that we think are relevant to today's discussion in the comments feed next to this video. So like I said before, we are going to be touching on a bunch of different topics, some of which could be, their own Facebook Live discussions and have been in the past. So if we find that materials might be helpful to you, we'll be sure to post those for your review and for your reference. If you have questions at any point during today's discussion, please feel free to also post those in the comments section. We'll do our best to either respond directly in a message or perhaps even discuss the question today while we are all here talking about back pay. And the last thing is definitely feel free to reference our website for additional materials. That's where everything is saved. You can find our blog posts and past videos that we've done at www.cck-law.com. So without further ado, Christian, can you tell us, just generally speaking, to start us off, what is back pay and why we refer to it as retroactive benefits?
Sure, absolutely. So back pay or retroactive benefits is money that a veteran becomes entitled to because of some sort of grant when the effective date, which we'll get into explaining a lot of issues surrounding effective dates, means that the amount of money they were getting paid wasn't what they should have been getting paid. So if the veteran, let's say, I always like to use hypotheticals. So back pay would be if a veteran was given a 30% rating, but then somewhere down the line, it was decided that they should have been at a 50%. So back pay is the difference between the 30 and the 50% for the number of months that you were rated basically incorrectly.
So pretty much the idea is that if the entitlement arose, and that's another idea that we'll talk about later, but if your entitlement to the benefits you're seeking arose prior to the date of the decision that grants you those benefits, you need to be compensated for those past months, sometimes even past years,
sure,
depending on how long the claim is pending, as if, you were being paid all along.
Yeah, it's what you should have gotten, but you didn't get.
Got it. And Mike, why don't you tell us about what effective dates are and why those are so important and why we'll be talking about them a lot as we discuss back pay?
Sure. So effective dates really are important in determining the amount of back pay that a veteran will receive. It's essentially the date from which the benefit that's been granted was warranted, or from which the benefit is entitled from. So basically, the general rule for determining an effective date is that it's the date that VA receives the veteran's claim or the date that entitlement arose, whichever the later date is. And so kind of a common situation to help clarify that general rule is, a veteran is diagnosed with a condition but didn't file a claim for maybe 5 years after the diagnosis of that condition. They may not be entitled to benefits until the date that VA received their claim, not necessarily the date that they were actually diagnosed with the condition or the date when the in-service accident or occurrence occurred. So it's really an important distinction in determining entitlement.
And I think your point, Mike, about the date that entitlement arose and also the date of claim, those can get a little bit tricky to figure out. But I think the scenario that we see more often, and maybe you two can weigh in on this, is typically the effective date is going to be the date of the claim.
Yeah.
So usually entitlement hopefully will be established by that point. But a question that we get a lot is, why can't it go back earlier? Why can't it go back to the date of my in-service accident or the date of my diagnosis 10 years ago? It goes by the latter of the two pursuant to VA's regulation. And so typically you wind up with an effective date being the date of your claim.
Yes.
Would you say that's fair?
That's
Absolutely.
actually fair, yes.
And in addition, the effective date being the date of your claim means that for however long it takes VA to work on that claim, say it takes them 2 years to ultimately decide on the claim and grant you benefits, that 2 years based on the effective date of the date of claim is going to set your back pay amount.
Yep.
Right. The idea, of course, being that, as Christian alluded to before, the veteran really was entitled to these benefits that they weren't being paid. And so now this back pay or retroactive pay is being awarded from the date of the effective date to compensate the veteran for essentially missing out on receiving payment that he or she otherwise should have received in the first place.
Makes sense.
Yeah.
And there are some exceptions to the general rule that the effective date is either the date entitlement arose or the date of claim. And one of those is if you file a claim within 1 year of your discharge from service. Christian, can you tell us a little bit about that exception? What's the effective date in that scenario?
It's going to be the day after you are discharged. You can't receive VA benefits as a veteran while you're in the service. So if you, like you said, Maura, file a claim within that 1 year, it's not going to be the date of claim, which you're going to hear over and over again, really, as your effective date. It's going to be the day after you were officially discharged from service.
And Mike, what about increased rating? So we've been talking about claims generally. Are the rules for effective dates and therefore back pay any different when we talk about increased rating claims?
So if a veteran files an increased rating for a condition that has been granted many years ago, the same rule applies, generally speaking, where the new effective date will be the date that VA received the veteran's claim for an increased rating of that condition. And so that's why it's important that a veteran submit a claim for an increase as soon as they feel that the severity of their condition has worsened, because VA oftentimes is going to grant a benefit. If they do grant a benefit, they'll grant the benefit back to the date of that increased rating claim.
And Christian, what happens if you file an increased rating claim and say you're waiting for VA to adjudicate your claim for years, maybe say 3, 4, 5 years.
Sure.
If your disability that you have claimed an increased rating for, the one that's on appeal, is still continuing to worsen throughout this time period, is there any way that you could receive even more retroactive benefits to account for that worsening?
Yeah, absolutely. So as we all know, and unfortunately veterans that are involved in this process watching, it can take a really long time to get a claim finally adjudicated, and even longer to get it granted. So there's a concept of staged ratings. So you file a increased rating claim in 2010. You get a rating decision, and then you all get all the way to the board. What the board is supposed to be doing is looking to see how severe your disability was throughout that, now I'm forgetting my hypothetical, 5-year period. If it was at a 30% level for a year and a half, and then at a 50% level for another year, and then the last part of the time period it was at 70, you can be granted all of those ratings, and then they have to calculate the back pay based on those 3 separate and distinct ratings during that 5-year time period. So it's not like you have to say you should tell VA that it's worsening, but they don't see evidence of worsening during an increased rating claim as, let's say, a new claim, or rather they shouldn't.
Right, because you have already filed the increased rating.
It's already
claim.
on appeal.
Right.
Exactly.
And so sometimes when VA is adjudicating increased rating claims, they will seek additional medical evidence and try to develop that claim. And sometimes that evidence might reveal that the disability is at varying stages. So if you see that in your case, it's important to think about how that will change the effective dates possibly for different stage ratings, as you were mentioning. We do have a question from Stephen. Stephen, thank you for your question today. In talking about back pay, Stephen wants to know how much of the back pay that a veteran receives can an attorney legally take as their fee? Does anyone want to take this one?
I could try.
Sure.
I guess what's most important is when you're working with a representative or an attorney to understand the agreement that you have come to. Because there is I think it's by regulation, correct me if I'm wrong, VA will withhold when there's working with an accredited agent or an attorney, 20% of a retroactive benefits, if you have that agreement, of course, for VA to withhold for your attorney. I don't think that there's any limit other than what a veteran would be willing to pay their attorney, but I don't actually know the answer to that question.
I think there are certain limits that are deemed reasonable automatically.
Okay.
And I believe that it's 1/3, so 33 point whatever it may be percentage, I believe is automatically deemed reasonable if it's below that level. That being said, though, as Christian said, it's really important for you to understand the agreement that you sign with a representative, and inquire and have questions about that.
Right, I agree. So I think by regulation, as Christian said before, there is a ceiling, that 1/3 ceiling. So it can't exceed that amount. But to Christian's point, all agreements are going to be different. So it's important for you to understand what your agreement is. Sometimes there will be additional provisions about costs and things like that that could change the amount of benefits that can be recouped by an attorney, or it's whatever the agreement says, but there also is the protective regulation so that attorneys can't charge, say, 50% or 75%. That would be unreasonable, and the regulation recognizes that. So before we were talking about how increased rating effective dates are treated pretty much the same as other claims. The effective date is either the date entitlement arose or the date of the claim, but we were talking about stage ratings if a condition fluctuates in severity during the rating period. But conversely, Mike, sometimes VA decides to reduce ratings, meaning that they decide that a condition has actually gotten better, and so the assigned rating needs to be lower than what it is. How does the effective date work if VA successfully reduces a veteran's rating?
So typically speaking, reductions occur when VA receives evidence, usually through a C&P examination or a compensation and pension examination, and they review the examination, maybe they review some new treatment records, and VA decides that your condition has improved. And so what they will typically do then is go through a process of proposing to reduce your benefit. There's a period to respond to that proposed reduction, and then if either the veteran doesn't respond or they do respond and VA nevertheless decides that a reduction is warranted, they'll go ahead and finalize that proposed reduction. At that point, they typically set a date for the reduction to take effect. And so sometimes we'll see veterans that went to a compensation and pension examination for an orthopedic condition. It's shown that the orthopedic condition improved based on the results of that examination, and VA will reduce based on the date of either the examination or maybe sometime in the future. And so I think it's important that if a reduction or a proposed reduction is issued in your case, that you, number one, certainly respond, but also understand that if the rating reduction is finalized, then your compensation will be reduced as of the effective date of that reduction.
I think it's a lot more common to see the scenario where the proposed reduction doesn't take place until after all that documentation has been sent to the veteran. So it's usually not retroactive in that it would go very far back. At least that's what we see more often. They'll propose to reduce it right around the date that the decisional documents go out. So that's an important point to be aware of what they're suggesting as the proposed date, because that's going to determine whether your monthly payments are going to change in the future and how far back into the past they could be changed depending on what VA is proposing. So that's a tricky subject. Again, I think that's a subject that we've tackled in other blog posts and other videos, so definitely feel free to reference those if you are in the circumstance where VA is trying to reduce your rating, because there's a lot of procedural steps that they need to go through that they don't always get right.
Absolutely.
That might be ripe for a challenge at some point in that process. Again, everyone, we're here this afternoon at Chisholm and Kilpatrick in Providence, Rhode Island, talking about back pay. My name is Maura Clancy. I'm here with Michael Strito and Christian McTarnigan. So far, we've talked about, we've focused on what it means to have a certain effective date for a claim or for a reduction, because that's going to be very crucial in determining what amount of back pay you're entitled to, if any. So continuing on with these topics that we have, Mike, if a veteran is reopening a claim that was previously denied, sometimes this can be a point of confusion. There might be an old claim that was denied, an appeal was never filed, and then the veteran later seeks the same benefits in a new appeal.
Yep.
How does the effective date work in that situation?
This is an important point, and generally speaking, there are exceptions to the rule, but generally speaking, if a veteran receives a final decision and does not appeal within the necessary time frame of that decision and would like to later file a claim, as you said, to reopen that condition and seek service connection for that condition, the effective date will be assigned from the date of the new claim that's submitted to reopen. And so just because veterans have submitted claims many years prior doesn't necessarily mean that they're going to be entitled to an effective date that dates back that far. And so I think it's, in determining and analyzing your specific case, it's important to remember that you really want to look to the date of claim for reopening the condition, and that usually governs.
Great points. And Christian, sometimes we see a change in law that has an impact on the effective dates for benefits. So if VA changes a law that makes a veteran eligible for benefits that before the change in law they were not eligible for or not entitled to, how is the effective date established in that situation?
Yeah, so, and also one point I wanted to make, we're speaking in generalities, because there are, and we deal with it every single day, there are a lot of issues that come into this. So I just want to make that clear. In this particular, the answer to this particular question is going to be extremely general because this is an incredibly complicated, or can be, area of the law. Generally, when there's a liberalizing law change, that means that, like you said, it's easier to get a certain benefit or something to that effect. If you file a claim based on that liberalizing law within a year, I believe, the effective date can be the date of the liberalizing law when it went into effect. After that, it's going to be no different than filing an initial claim like we were talking about before. An increased rating, it's going to be the date of the claim.
Right, makes sense. So as we mentioned before, the default, typically we're talking about the date of claim a lot, but we're trying to highlight some of the areas where it gets a little confusing and where there are some exceptions. So
Absolutely.
Thank you for explaining that one. That's a tricky one. That trips me up a lot, honestly.
Yeah.
And Mike, how do effective dates work for DIC benefits? So this is another situation where sometimes it can be difficult to parse out what the effective date should be, because DIC benefits, dependency and indemnity compensation benefits are awarded to surviving spouses of deceased veterans. So that can get tricky. Can you tell us a little bit about that?
Sure. So the common situation is, unfortunately, the veteran passes away and his or her spouse wishes to be subbed into the claim, essentially, and files a claim for, as Maura said, DIC, dependency and indemnity compensation. The effective date rules in this area are essentially if the surviving spouse files the DIC claim within 1 year of the date of the veteran's death, then if DIC is granted, the effective date will be the date that the veteran actually passed away. However, if the surviving spouse in this hypothetical files the claim for DIC after that 1 year period, then just like we've been talking about all afternoon, the effective date will be the date of the claim. So again, it's really important that if this is a claim that you would like to file, to do so within that 1 year time period, if possible, to achieve the earliest possible effective date for that particular benefit.
Okay, so it's not just a default, it's the date of the passing of the deceased veteran.
No, it's not. And that's a good point. I think this is an area where unfortunately veterans and their spouses get tripped up. It's not always the date of death. It can be, but again, that's only if the claim for DIC is filed within the 1 year period post-death.
Great. And Christian, can you talk to us about clear and unmistakable errors that are found in VA decisions? We call these Q claims or Q allegations. For just as background, if you allege that there's a clear and unmistakable error in a decision, you can bring that up at any time after the decision is issued. So say a veteran says that they believe there's clear and unmistakable error, or Q, in a decision that was issued 20 years ago, and say they're successful in persuading the VA that there was a Q in that decision.
Yeah.
How does it work if they're entitled to retroactive benefits? What's going to be the effective date for that?
So talk about...
Generally speaking.
Yeah, talk about complicated areas of the law. So the answer to that question generally is pretty easy. Basically, the VA should not have made the mistake. And when a veteran, either on their own or through a representative, files a Q motion alleging that there was clear and unmistakable error, which is a completely undebatable error, it's as if that decision was never made improperly. They basically put a new correct decision in the old decision's place, 1977, 1980, 2004, and it's as if it never happened. So like we were talking about before, it's as if you got a grant with an effective date all the way back to the date of the decision. If of course, the Q motion is successful and you get a grant. So just like we were talking about before, if your overall level of disability is increased as a result of that Q revision, then you're going to get the same back pay as you would if there would be a grant. So it would be the difference between what you were rated at then and what you're rated at now correctly for that many months. And it can be years.
Right. And sometimes if it's a very long period of time, there is a possibility for a substantial retroactive payment.
Yeah.
And since we've stuck with you pretty much for the complicated stuff, we're getting to more complicated stuff for you later, Mike. But Christian, there's some differences and there's some more complicated nuances when it comes to back pay in Nehmer cases.
Yeah.
Tell us about that a little bit,
Sure.
just briefly, because I believe that we have some materials on Nehmer that we will make available, and we don't want to spend too much time on it, but it is important to note, I think, in this discussion.
Well, this
generally.
can be a seminar talking about Nehmer, but keeping it incredibly simple, you have to meet the requirements of the Nehmer class. And one of those requirements is being boots on the ground in Vietnam. So basically, if you have filed a claim between 1985 and 2010, I believe, and meet the other requirements of Nehmer, one of which is boots on the ground, you can, and you have, of course, a disability and you've met all the elements, diabetes, for instance, right, is linked to Agent Orange exposure, then you should have your claim granted all the way back to that initial. So everything that we've talked about goes completely out the window when you're talking about Nehmer claims, insofar as when your claim is effective from. Because, if you were thinking about some of the other rules, the date entitlement arose would be quite later, but none of that applies to Nehmer claims. If you filed your claim in some sort of way between that time period, and you have a presumptive condition or a condition that's caused by your service in Vietnam due to your exposure to Agent Orange, you'll get the benefit of that effective date. Okay.
So safe to say that Nehmer is something that only helps. It can maybe get the effective date sooner than the claim.
Absolutely.
If it applies, if all the other requirements are met.
Yes.
And also, as we've been alluding to or sort of expressly stating throughout this discussion, these are pretty complicated areas.
Yes,
so
absolutely.
If you think that you have a case that falls into some of these categories, we would definitely recommend getting in touch with a representative, an attorney, someone to help you out, our colleagues at DAV. Anyone that can help you navigate the complexities of these things, because they're very difficult. Effective dates on their own can be tricky to figure out, never mind when there are liberalizing laws and rating reductions and Nehmer issues that are flying around. So highly recommend getting some assistance if you think you need it. And again, we'll just remind our viewers that we're here today at Chisholm, and Kilpatrick in Providence, Rhode Island, talking about back pay. We still encourage you to post any questions that you might have in the comments feed next to this video. And additionally, please review the comments at your convenience to see if there's any information that we've posted there that might be helpful to you. We do have some blog posts on a lot of the topics that we're talking about today, and so we want everyone to be able to take advantage of those materials that we're posting throughout today's discussion. Now we're going to talk about compensation and offset. So not just back pay, but when is back pay limited by receipt of other benefits, and a whole lot of things that continue to get trickier and trickier as we move along. So, Christian, just start us off briefly. How does VA generally calculate back pay over long periods of time? So say that VA decides that a claim that's been on appeal for several years can be granted. They set the effective date years in the past. How are they going to figure out what the veteran is entitled to for a retroactive award?
Well, they would have to go to the historical tables that show how much a certain rating was worth, or how much you were supposed to pay the veteran at that time, because in 1977, the value of a 10% rating is much different than it is today. So basically, they go back in time. They say, for this amount of time, 10% was worth X amount of money. And then from this period of time, a little later, it was worth this amount of money. They add it all up, and then that's the check that they cut.
Okay. So good thing to know that they are adjusting these things year to year if the compensation rates change.
And this should all be on VA's website. When I've had to do that in the past, or I was just curious, I've gone to VA's website and they have a lot of the historical tables, and we'll be able to point you towards that. So to help you find it a little bit more easily, to get some sort of idea of what you might be entitled to, so you're not confused when maybe you're using a $2018 amount. When it goes back farther, it might be a little bit less.
Mm-hmm. And they can be going back very far in the past in terms of calculating retroactive payments, because as we all know, there's no cap on what you can receive for a back pay. So, and
we were just talking about Nehmer claims, 1986 to yesterday. That's going to be a big check, and the amount that you pay per month per disability rating is going to go steadily up from 1985 until the present table.
Great. So there are some situations, as I mentioned earlier, where an award of retroactive benefits or the back pay that a veteran receives might be offset by other benefits that are being received by the veteran at the same time. So Mike, can you tell us about what offsets are generally and what recoupment means? So I think recoupment alludes to when VA needs to take funds back from a person that they've paid.
Yes. So as you both have just said, there aren't any real limits to the amount of back pay necessarily that a veteran can receive, but there are what's called an offset. And that means that the veteran's back pay may be reduced by some other pay that they received, some other benefit that they received. And so if that's the case, VA will recoup or take back that previous benefit to offset the new benefit in disability compensation that they're awarding. So, for instance, one example of this is separation pay. Separation pay is essentially a one-time lump sum given to some veterans that are denied reenlistment or denied continued service. And so, generally speaking, there are exceptions, but generally speaking, separation pay is something that must be offset if a veteran receives disability compensation. A second example is severance pay. So again, severance pay is a one-time lump sum given to some veterans who are discharged from service due to a disability. And similarly to separation pay, severance pay must also be offset prior to the veteran receiving disability compensation. So those are two examples of where VA will offset or take back certain benefits that were already paid out once a veteran is now service-connected and going to be receiving service-connected disability compensation going forward.
And what about pension?
So pension is a needs-based program, whereas VA disability compensation is compensation paid out for service-connected disabilities. And essentially, a veteran will receive the higher of the two benefit. So they won't receive both benefits. They won't receive pension and disability compensation. Once a veteran is service-connected and receiving a high enough rating, combined rating, typically, I would say the disability compensation is the higher award out of the two. And so that means a veteran that may have initially started receiving pension will then begin receiving disability compensation and no longer receive pension because it's the higher of the two disabilities.
That makes sense. So when pension is concerned, you can't receive both at once, but you do receive the higher of the two.
Correct.
Which is great.
That's correct.
Any other offsets that you know of that are worth mentioning? And again, we will be making any materials available about these offsets because these are particularly tricky
Yeah.
and could be topics of their own. But any other ones that you want to flag for us?
Yeah, absolutely. I think retirement pay is something that a lot of veterans deal with and see withheld or recouped from VA when they receive disability compensation benefits. And it's as Maura said, it's a very confusing area. There are a lot of technical rules in this area, but generally speaking, the general rule has always been that veterans really can't receive both retired pay and disability compensation at the same time. But there are exceptions to that. And one such exception is called concurrent retired and disability pay. It's called CRDP. Basically what this means is that certain eligible veterans are entitled to receive concurrent receipt of both their retirement pay and their VA disability compensation benefits. Some of the eligibility requirements are that veterans have to have been a 20-year military retiree, and they must also have a combined disability rating for their VA disability compensation of 50% or higher. And so if veterans meet those two requirements, essentially, then they may be able to receive concurrent receipt of both their retirement pay and also their VA disability benefits.
Great. And the rules about DIC that we touched on before, there's no kind of different calculation that's done for back pay for DIC, right?
It's basically based on the rules that we stated before. It's the, if a veteran's surviving spouse, for instance, files a claim within the 1 year from the date of death, then any back pay that is received will go back to the date of the veteran's death. If the veteran's surviving spouse files a claim for DIC outside of that 1 year period, then the same general rules as we've been discussing apply. It's the date of claim, so back pay would go back to the date of claim, not necessarily the date of the veteran's death.
And one thing I want to note, we've been using spouse as sort of a proxy for dependency and indemnity.
Yes.
There's also dependent children as well as, I believe, dependent parents.
Yes.
Correct.
But two people can't take at the same time. So a surviving spouse can't get DIC and the dependent child can't get DIC. But if one is not present, then the other person would be able to receive that as well. And the money is different. There's a whole different table. VA loves tables and numbers and rules. So I think it's $1,300 a month presently, but again, that would change if it were to be a claim that was filed a long time ago. That is also adjusted.
And a lot of these rules, particularly these offset rules, they've been created to kind of apply the general principle that they don't want veterans, VA doesn't want veterans essentially double dipping. And by that they mean receiving two benefits for maybe the same condition or the same issue. And so that's when VA will offset or recoup certain benefits that have been previously paid to then pay the veteran disability compensation going forward.
Makes sense.
And one thing I want to note before we move on, VA should be doing this all correctly. Sometimes they are not doing this correctly. So these are the rules. And if you are getting paid for two of these things at the same time, that wasn't supposed to happen, and VA can come back and ask you to repay this, either by taking a percentage out of what you're getting paid each month or asking for payment back at a certain. So it's not like, not to suggest that anyone would do this, but you're not getting away with anything. Please let VA know about it so they can correct it, and you won't have to have an overpayment on your account. Isn't it an account?
Yep.
In the system for you, because that could be a pretty large burden.
Definitely.
And it's not like they just forget about it.
And that's a good point. And piggybacking off of that, when we're talking about the concurrent receipt of retired pay and disability benefits, it's important to know that this isn't something that veterans need to apply for. As soon as they meet that criteria when a new grant is issued to the veteran, VA should be doing this on their own. Of course, it's important to double check the work for sure and make sure that it's actually happening. And if you have a representative, it's something you should speak to your representative about. But it's not a separate application. It's not a separate claim form that needs to be filed for a veteran to receive concurrent receipt of the retired pay and the disability compensation.
Great. And the last thing we wanted to talk about today was if you receive a retroactive award and you think that it's not the right amount, specifically if you think that it's too low, then the effective date for the award might have been incorrectly decided. So what are your options if you receive an award or you receive a grant but the effective date doesn't look like what it should be, Christian? What can you do if you disagree with the effective date that's assigned?
You should appeal. And we're talking about sort of the legacy system here, I think, for most of this. But you need to appeal it. And if I'm remembering correctly, on the form that you're required to use, at least presently, there's an effective date choice. You can either appeal everything that happened or you can select rating or effective date. Just make sure that you're being very clear what you want to appeal. You should appeal it. You should, if you think that they did it wrong, you should always appeal it, because if you don't appeal it in the correct amount of time, then you're going to lose that right.
Right.
And as you can tell from our discussion, and as we've said, this is a very tricky area of the law, and VA doesn't always get it right. And so I think it's very important for you to not just necessarily rely on and trust in whatever is granted. Make sure you're taking a double check back and seeing, is that the date of the claim? Is that the date of my diagnosis? Is that the date that I refiled? And based on that, if you think, as Christian said, that your effective date is improperly granted and it can go back farther, you should definitely appeal.
And if you appeal, what kind of evidence or argument would you want to submit, either of you?
I think it's important, to the best of your ability, I think it's important for you to lay out the kind of the procedural history of the claim. And I know that can be difficult if you don't have access to your entire file, or maybe if you don't have a representative, but I think laying out clearly kind of the procedural history of your case and showing VA when a claim was filed up through the current decision, I think that is really beneficial in making your argument that you deserve an earlier effective date.
Because one of the pitfalls is VA will interpret a statement or some sort of submission that wasn't intended to be an increased rating claim as an increased rating claim when you already had an increased rating claim on appeal, maybe from years before. Right. So definitely second what Mike says about the effective date. And I think I'll comment on stage ratings because I think we've already talked about the more classic mistake. In those situations, if within an appeal period you think you should have gotten a higher rating, what's really important is to point to the evidence in the file that you were entitled to it. You had more severe symptoms. VA either missed evidence or downplayed the symptoms that you're having. Trying to point out when and how you can show that your condition worsened within a 5 or sometimes, unfortunately, 10-year appeal span. I think that would be a good idea.
Yeah, I agree with both of those things. And I think, we see a lot of issues with this, but one thing that we see frequently is a veteran will file an increased rating claim. It'll take several months or several years to get an examination to assess the severity, and then by the time the decision comes through, it might grant the increased rating, but only as of the date of the exam.
Sure.
Despite the veteran's contentions that the symptoms were worsening prior to the exam. So I would take Christian and Mike's advice. If that happens to you, set forth in an argument, this is the date of my increased rating claim, and the symptoms that are documented in this exam were actually affecting me before that.
Sure.
And the more specific you can be, the better.
Yeah.
Because sometimes VA will say, well, we don't really have a whole lot of evidence, so we had to pick the day of the exam because that's all that we had to go off of. But usually the veteran knows their symptoms better than anybody else, if not always. So they should speak up about when the symptoms began to affect them, and that can sometimes help to cut off these effective date problems.
I love when clients write into the VA when I work in the court, when I'm handling an appeal, just writing a letter saying these are the symptoms that I'm having. The VA examiner didn't talk about all of them, or here's what's happening to me now. I've literally had clients that have been so precise in explaining it that I just take what they say, and it's all great to be able to help advocate for you, on your behalf when we get to court. So it's great advice.
For sure, and that's something definitely to think about when you go to an exam. I think, as you both have said, it's important to not just state what your current symptoms are, but if they've been occurring at the same severity level for the past several months, several years, I think that's something to tell the examiner and make sure that they jot down, because oftentimes, as we've said, when assigning an effective date in a staged rating situation, unfortunately, VA will assign the date from the actual date of the exam, which isn't necessarily the proper thing to do.
And I know we have a video on exams because I was in that. So be look out for that to sort of follow up on Mike's great advice.
Yes.
Great. Any other questions? Do we have anything else? Anyone want to add anything?
I'm good.
Good
I
to
think
go?
that's it. Yeah.
Perfect. So thanks everyone for joining us today. As we said, please look at the comments feed next to this video for any additional materials, and definitely feel free to access our website at www.cck-law.com. Again, thanks everyone for joining us to talk about back pay today, and we hope you have a great afternoon.